May it please the court. Michael Lefferman on behalf of the appellant Larry Bean, and I'd like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this morning on the first claim raised in the briefs, and then of course I'm prepared to answer any questions that the court has regarding the remaining claims. The first claim concerns whether the trial court erred by denying the motion for new trial after it was established that Juror Kuhn was not truthful on the juror questionnaire. So after the trial in this case, there was an investigation that was conducted, and the investigation and the subsequent juror interview of Juror Kuhn established that Juror Kuhn did not answer the following question truthfully. On the juror questionnaire it says, have you or any member of your family ever been accused, complainant, or witness in a criminal case? And Juror Kuhn checked no on that form. It was later established both in the investigation and then during the June 4th, 2024 interview that Juror Kuhn had a son who had previously been trespassed from her property. Juror Kuhn had the father of that son who had been arrested for DUI in 1997. Juror Kuhn had a father of another son who she said, quote, had 2 DUIs in Florida and a couple more in Wisconsin. And then Juror Kuhn was shown a police report from May 18th, 2017 from the Walton County Sheriff's Office that established that the Juror Kuhn's son had a father who lived out of state because he was an alcoholic.
And I'm going to call it the De La Rosa test because that's the Supreme Court case.
Yes.
At the Mitchell case.
Yes,
cited,
correct, Your Honor.
Is it a strict liability type of thing? So if what you're doing now, you know, you're just, okay, she answered no on the questionnaire, and then you got all this documentation that is contrary to that answer, is that the end of the inquiry for that particular prong, or does there need to be more? Like, you know, the standard talks about conceal, so does that require there to be more of a showing than just there's a conflict between the answer and the facts? Does she have to clearly remember all of that and then knowingly not answer correctly on the questionnaire? Or is the inquiry just what you're doing right now?
I think, well, maybe two answers to that. I don't think you're asking about materiality. Materiality obviously is the first prong of the test. As far as, you know, the case law is clear that it doesn't have to be intentional. So we don't have to establish that she perhaps intentionally withheld this information. I think we have to establish.
It could be accidentally concealed.
Correct. That is true.
Is that possible? Can someone accidentally conceal something?
You know, I don't know. I don't think there's any indication that that's what happened here. When she was questioned during the jury interview by me, she acknowledged all of these facts. She didn't say that I didn't remember them back then. This has just come to my attention now, or I just now remembering this. She gave no explanation as to why she didn't answer truthfully on the form, but yet she acknowledged that she had all of these family members that have had significant issues with alcohol. Many of the men in her lives had criminal history based on alcohol-related incidents. So I don't know how to answer your question, Your Honor, other than, at least in this case, there is no claim that she didn't remember at the time. I think that could be a closer case when you're looking at the case law that says it doesn't need to be intentional. It could be accidental. But here there's no indication that it was accidental. Every indication was when she's asked about it, yeah, she acknowledges this is my family history.
Can I ask you about the third prong then of the De La Rosa test?
Of course.
The due diligence, and I know you were retained after the trial. It's appointed counsel, so we're not talking trial of the century with jury consultants and such there at the trial level. Nonetheless, there's some time after jury selection. It's a few days later before the trial. So if this is going to be an issue, was there not a requirement for then appointed counsel to do some kind of rudimentary record search at least to see if any of the 6 jurors and how many of our alternates had any kind of misrepresentations at that point?
I think that's a But the state has raised that. I've had this issue come up in other cases around the state, and that's been discussed. I think that's perhaps an interesting policy consideration about maybe changing the rule, but council's entitled to rely upon 3.575. And 3.575 now says that juror misconduct issues must be raised within 10 days following the verdict. Now, obviously, our case is a little different because we have the good cause exception that was met. But any reasonable defense attorney relying upon that rule would not believe that there was any requirement to have to do this in the middle of the trial, and there is this time period up until 10 days following the verdict. Now, could there be a really great discussion within the Criminal Procedure Rules Committee about whether or not this is something that should be done earlier? Sure, and I would love to engage in that discussion as well. I think the one side of it is defense counsel, especially as you've already indicated, this is not the case of Century. We're talking, single counsel. There's not a defense team. Defense counsel is focused on moving forward with the trial once that jury is selected. They're not focused on, do I need to spend extra time going home at night and trying to track down a juror investigator to do this type of work. But more importantly, again, defense counsel wouldn't be led to believe that that's something that needed to be done because the rule as currently written allows for that 10 days after the verdict.
If I agree with you on that, what about the materiality of the false statement? A correction officer served, which seems a little odd to me that you'd put a correction officer on a jury, but not you, but the trial counsel would. But a correction officer served, a juror who was arrested and claimed that he had been treated unfairly by law enforcement had served. So these misdemeanor offenses that had occurred 5+ years before trial, how do we analyze whether those were materials for the De La Rosa test?
I can go through each and every one of the jurors that potentially are question marks in this case, and let me do that very quickly. Mr. Rochelle is one of the jurors you referred to. Mr. Rochelle said two things. He said, number one, that he did have a prior arrest, but when asked about that by the prosecutor, he ultimately stated that he didn't feel that he was treated fairly by law enforcement. That's potentially something that defense counsel strategically would say, I want that juror, because this juror has a bad view of law enforcement. Mr. Rochelle also later said that he knew someone who had been a victim of sexual abuse. But ultimately, Mr. Rochelle was chosen as the alternate, was not one of the 6 that served in this case, did not render the verdict. But again, I can explain why defense counsel would leave Mr. Rochelle on and not strike him as the alternate, because he gave a very favorable answer from the defense standpoint that he did not have a good experience regarding his arrest relating to law enforcement. He thought he was treated unfairly. There was 4 other jurors, Miss Rodriguez, Mr. Matthews, Miss Bird, and Miss Windhorst. They were asked just about the facts of the case. Could you be fair after hearing just what the charges were? All of them said no. Every one of them was stricken for cause. Both parties agree, and the judge agreed as well. Mr. Miller, he said that he does not drink. The state says in their answer brief that, defense counsel didn't use a peremptory challenge on Mr. Miller. The defense counsel wasn't even given that opportunity. If you look at jury selection, as soon as the judge ended the cause challenges, any more cause challenges? No. Okay, state, peremptory challenges to you, and immediately the state is the one that strikes Mr. Miller. For all I know, defense counsel would have. Defense counsel wasn't even given that opportunity. The state struck Mr. Miller before the judge even asked defense counsel about peremptory challenges. Ms. Dykes is the only other one that answered that she does not drink. We don't know. Ms. Dykes was never in the 6. For all we know, defense counsel would have stricken Ms. Dykes had she had the opportunity to. There was 2 other jurors that said that they know of people who drink excessively. Unfortunately, in this transcript, I think this is on page 50, is there anybody else that has a friend or family or close relative that drinks in excess? Prospective juror, yes. Prospective juror, I do. The transcript of our jury selection only refers to our jurors as prospective jurors. We only know their names if the party asking the question then followed up and said Ms. Dykes, Mr. Windhorst, whatever it might be. For all we know, those 2 prospective jurors were 2 of the prospective jurors that had already previously mentioned that they couldn't serve on this case, so there was no reason to follow up because there was already going to be a cause challenge that subsequently was granted. So I submit that there's nothing in this jury selection transcript that indicates that defense counsel was in any way deficient or failed to follow up on issues relating to alcohol. There's no juror who sat on this case that had any issue with alcohol. And therefore, again, when you look at alcohol being such a key issue in this case. I think the trial court, when discussing the third issue in our case, whether to give the voluntary intox instruction, specifically said, this is page 394 of the trial transcripts, the trial court calculated there were between 9 and 14 beers consumed by my client on the date of the incident. When, after the incident, when there's body cam, when my client's being questioned by the family, my client is completely out of it. My client's statements were, I don't remember any of this. Alcohol is a key issue in this case. I submit that any reasonable defense attorney would not want Juror Kuhn to be on this case. It doesn't mean there's anything wrong with Juror Kuhn. She may be a perfect juror for another case. But in a case where alcohol is a central issue, and you have a juror who, it seems like every man, including her sons in her life, has had problems with alcohol, that's what any reasonable defense attorney would say, she's just not an appropriate juror for this
How
case.
far back do we go in looking at the materiality? So say she had made a false statement, her father had a DUI in the 60s, that she had forgotten about, or maybe she even fraudulently conceals it. At some point, that's not going to be material.
I agree.
So how do we balance that, or is that something that the trial court balances?
Well, it's a great question, and let me just quickly address the second part first. The trial court didn't balance any of this. I think the state concedes that when they recommend that this be sent back. The trial court did not address any of these factors and I attempted to. The trial court said, what about the three factors? I would address the three factors, and the trial court never said anything. But I think a couple things with materiality. I do think the standard has to be, materiality, the courts say, if defense counsel had known, would reasonable defense counsel have exercised a peremptory challenge? Not a cause challenge, doesn't rise to that level, but just a peremptory challenge. I do think it's a reasonableness standard. Now, I will note that I proffered in the record when this case came up, and there was a question about whether or not I was asking for the judge to find good cause. I was asking for the judge to find that we'd met a prima facie case under the three factors. And I said I had both Ms. Peterson available and also had Ms. Gooden, the trial attorney, available. And I proffered, and this is on page 442 of the record, I proffered that Ms. Gooden would have said that she, in fact, would have stricken this juror had she known about Juror Kuhn's past. And the judge kind of moved right through and said, State, we don't need to deal with this. You agreed that the juror should be interviewed, and the state agreed. So there was no further discussion about any of that. But I'm not saying that just because Ms. Gooden said that she would have stricken the juror, that all of a sudden that means I meet materiality. I think it's an objective test. So I think the court has to look at it objectively. If you had if you had the only issue with alcohol for a particular juror going back 30 or 40 years, well, that's a much weaker case for me to be able to say, oh, no reasonable attorney would have failed to have used a peremptory challenge on that juror had they known. But when you look at the extensive impact that alcohol has had on Juror Kuhn's life, with not only at least two fathers of her children, one the police report referring to as an alcoholic who lives in another state, she acknowledging that one of them had 2 DUIs in Florida and others in Wisconsin, another one having DUI arrests back in Florida back in 1997, and then her own sons. The date of this incident, her son came home, grabbed a bottle of rum, drank it, and then became aggressive and started biting her current partner and threatened to kill both her and her partner. Clearly, alcohol has had an impact in Juror Kuhn's life. And therefore, I submit that, it's not a situation that you have just one incident from 40 years ago with a grandfather. You have, it seems like, every man in her life having this major impact with alcohol, and therefore no reasonable attorney, Ms. Gooden included, as was proffered, would not have stricken her had she been truthful on her jury questionnaire. I believe that all three factors were met. I believe there was nothing else that Ms. Gooden needed to do during jury selection. Attorneys have a right to rely upon these answers. This is why we have the jury questionnaire. It can't be that every attorney would have to get up and say, okay, on your jury questionnaire, you answered yes to this question. Is that correct? You answered no to this question. Is that correct? That would defeat the purpose of juror questionnaires. So when she said no, I've never had anyone in my family been accused of a crime, and I've never been a complainant or witness to any type of crime. And we now know that was patently false. Ms. Gooden had a right to rely upon it. There was no point in doing any follow-up. She said no. And I think it was material. I think it would have resulted in a peremptory challenge. I think it's established under the second factor that it was clearly false. And I think that this requires my client to get a new trial. He was misled. We rely upon jury selection. Some lawyers would say it's the most important part of the case, that you know whether you've won or you've lost based on the jurors that you've picked. We rely upon jurors to be truthful in the jury selection process. That's the only way it can work. So again, it's not that these jurors are right, or have done something wrong or improper. It's just, are they the right fit for this particular case? This juror withheld something that made it so defense counsel couldn't make that decision. And again, I submit that any reasonable attorney, had they known her true past, would have used a peremptory challenge, and that would have resulted in her not being on this jury. And that's the standard. We meet the three prongs, and therefore my client should get a new trial with a fair jury. Thank you. I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Efferman. Ms. Townsend.
Good morning. May it please the court, Darcy Townsend on behalf of the state of Florida, the appellee. This case really is about due diligence, and on Monday, the jury was chosen. On Friday, the trial commenced, and 3 days later, on Monday, appellant went out and hired, or his family hired, this covert ops team, which isn't even a private investigator, actually. Per her report, they are using public records searches that are ubiquitously available online now. A lot has changed since the De La Rosa case in 1995, when that information might be much harder to come by. But in the 3 days between trial and jury selection, there was plenty of time to comb through social media or do a rudimentary background.
And what would have happened, let's say the investigation that was done after the trial were done in these 3 days that you're focusing on. Walk through, what would the procedural outcome have been at that point?
Well, I disagree
What
with
would have
Mr. Offerman that any attorney would
No.
strike
Like,
this
the jury was
person.
selected on a Monday, and then the trial is later in the week, and you're focusing on, I'm assuming your argument is, well, they could have done the thing they did after the trial in the intervening 3 days between jury selection and the trial.
And if they were concerned about it, they could.
And then what would have happened, so if they brought the same information that they discovered from this investigating company after the trial to the court's attention in those 3 days, I guess, or I don't know how long it takes, but you know, you're focusing on that, and the due diligence they should have been doing this investigation right before trial.
Yes, Your Honor.
And my question is, well, then what would have happened? Okay, we discovered this juror, the questionnaire is not accurate. So then what? What would have happened?
They have an opportunity to bring it before the court's attention and ask
then
for the
what?
alternate, or move to strike the panel and pick another jury. But they didn't do that in this case. They could have brought it to the court's attention and tried to, or interviewed the juror even during,
So the
before
real
trial.
argument
but-
here is just because everyone's gone through the inconvenience of having this trial, so now the defendant should be barred. Because the result would have been you were not going to have that trial on that day. You're going to have to
No.
redo everything.
Not
theory.
necessarily. They also could have decided to proceed with this juror on the panel. We don't know, because they didn't conduct this search. We don't know that she would have struck this juror, that it would have been material information. Mr. Efferman didn't call her or call the defense attorney at the hearing, and he can't say that that the information was so egregious that every reasonable attorney would have.
Well, I guess what I'm
struck
really
her.
asking is the due diligence component of the test really designed to say, well, you know, yes, you did find that there was some false or inaccurate statements on this, and we know that, let's say it did make a difference, but we don't, it's too late. Sorry, you did it 2 days, like if you'd done it the week before, it would have been fine, but you waited till a week later to do it, and regardless of what the facts are, that doesn't count as due diligence. Because we know you could have done it this investigation, but you just didn't do it early enough. Like, should they have postponed the trial? Let's say the investigation, they hired that company, and the company was going to take like a week to do it. So are they supposed to ask for the trial to not go forward until that investigation's done?
Well, if they were concerned about this, they could have asked for something.
Well, maybe it's a
They could've.
routine thing that they do in every case. I mean, what's to say? You seem to be like taking what they did after the fact and projecting it back. Well, they should have done it earlier, and that counts as a failure to do due diligence.
Well, they could have done it earlier if they were concerned about exposing juror bias or misconduct. They could have looked into it, and the failure to do so is lack of due diligence.
So no defendant should ever, after they're convicted, should hire an investigation company to see if jurors were untruthful, because it shouldn't matter, because, well, if you were willing to hire them after the fact, you should have hired them before the fact.
Well, it's a Hail Mary. It's a type of, I would submit it's a type of sandbagging. You're keeping this in your hip pocket instead of this is a really broad
But what are they keeping
question.
in their hip pocket? No one knows if the jurors are being untruthful at the front end. Everyone assumes that the jurors are being truthful. That's the whole point. Otherwise, why put them under oath? Why
Well-
call it voir dire?
They're also asking broad questions. We hope the jurors are being truthful, but it's also, you ask vague questions, you're going to get vague responses. We acknowledge that there are going to be misunderstandings. They're not always going to understand the call of the question, that it's
But that's a different
difficult
problem.
to get people to talk. There are some people that, I'm sorry, Your Honor.
Yeah, but that's a different prong. Now you're talking about materiality, whether it's actually concealment, those kinds of things. But on the due diligence side, and we can move on, that's fine.
I
But-
think they go hand in hand, too.
Well, Mr. Ufferman points out the rule that currently allows 10 days after rendition of the verdict to move for the jury interview. So that would, he says, seem to imply that you've got some time after the verdict to look into any problems that you might have with the jury. What's your response to that?
He didn't show good cause. That's going to open, this issue is popping up more and more, so if we allow for 10 days every time somebody goes out and hires a private investigator, there's not going to be, and that automatically gives you good cause for however long it took them to dig up this information and go fishing for something that the juror may or may not have disclosed. That's going to destroy the finality of verdicts.
Well, I mean, I agree,
in every case.
if resources were no object, if this was some multimillionaire on trial for this, he would have had a team there, he would have had a couple of attorneys, he would have had a jury consultant, he might have had a couple of jury consultants advising him. They would have screened, you've seen the, what's the movie, Grisham, Runaway Jury, yeah, Grisham movie and the book on the jury consultants. That was 30 years ago that they were doing stuff like that. But your person with an appointed counsel is not typically able to do that during trial, and Jack is certainly not going to pay for that during trial, right? So what do you do?
Well, these are pretty simple searches. Even people looking into background checks for tenants or somebody going before they go on a date. There are public record searches that are available immediately and online that they can do. The appellant trial counsel could have had an assistant running or Googling these jurors. They certainly had the time between trial and jury selection to search for these.
So, are you saying that the due diligence imposes an obligation on trial counsel to disbelieve what the jury told you during voir dire?
If you're concerned about exposing bias, you need to make an attempt to do it before trial, or if you're worried that something didn't come out in voir dire, there are resources available to check that, and lawyers routinely do.
Have you ever been to trial
Yes, Your Honor.
as counsel, solo? As a solo practitioner?
Yes, I was prosecutor.
So Well, but I mean, as a solo practitioner, have you ever been to trial?
No.
So the idea of a solo practitioner who has jury selection on one day, presumably has multiple clients that they have to tend to, maybe even multiple trials that day. They may be selecting multiple juries that day. And the due diligence standard should be, well, every lawyer who is curious or concerned, or just as a matter of practice, they're going to do an investigation on their own. Instead of getting ready for trial, they're going to hit the internet after jury selection that day and look through every juror that's been selected to see if there is some inaccuracy in the questionnaire answers. Is that the suggestion? That's the standard of due diligence?
If you are concerned about that, and not every attorney is, some want to pick the first 6 people that are awake and alert during jury selection, but if you're wanting to make sure and not wait until after the fact then you need to exercise due diligence beforehand.
But in this case, that wasn't the lawyer that did it, it was the family that wanted to do it, right?
It's not clear how the record doesn't say, they say the family hired him. That could have been at the suggestion of the lawyer. The fact that this is popping up all over the state would suggest that.
Maybe there's a new company out there that's marketing this to defendants.
Or
But
defense
let's just
counsel.
say, instead of this being a formal investigation, 2 days after the trial, there's someone happens to know the juror, and they kind of like surreptitiously say, hey, just kind of like a whistleblower, hey, you may want to look into this juror. I happen to know that she was at the bar yesterday and was chatting about how she didn't disclose all the information. You should look into it. And then they go and search and find it. Is the standard the same? They say, well, but had you done a social media search the day of jury selection, you would have found that same information, so you're out of luck on that. Is that the standard?
No, in that situation, that hypothetical doesn't allow for that is information that they could not have known without due diligence, but what is turned up in this case is information that was available rather than somebody bragging at a bar that came to light a different way.
And the state's hip pocket concern is basically, no one's going to do this before they have a verdict because they might win, right? Then they won't need to do it. So they keep this
Yeah.
in their hip pocket, then later they're going to go do this because, hey, that's a second bite. So that's the
Exactly.
state's countervailing concern.
Exactly, Your Honor.
How do we deal with, if we disagree with you on the diligence part, and we say, well, the rule says 10 days, so this was diligent, or, it's something like Judge Tannenbaum's hypothetical where not even a search, somebody just out of the blue, this information is revealed within 10 days. How do we deal with whether it's material or not, then, the other, a different prong under the De La Rosa?
Well, it still has to, I believe one of the cases I cited talked about, it has to expose an inherent bias in front of the juror. Even at the evidentiary hearing, there was no showing that, while Mr. Efferman says that alcohol ravaged her life and affected most of the men in her family, her answers at the evidentiary hearing really don't indicate that. And that she acknowledged that her husband's had DUI arrests. It was attenuated. It was years ago. There was no further questioning even at the jury interview about how that affected her, if there was no exposure of any bias.
I thought the test was material to jury service. Didn't the Supreme Court later, like in Roberts v. Tejada, reference it's material to the juror's service? Because if you're talking about whether they're biased, now you're into a harmless error analysis, which I don't see mentioned in any of the Supreme Court's discussion about this area. Disagree?
It would still have to be relevant to the jury service in this case, and I believe the cases say on a case-by-case basis that there's not going to be a per se error, and it has to be evaluated. I would disagree with Mr. Efferman. I think the judge here did evaluate when he said this was an indiscrepancy. It doesn't go to whether or not she had any sort of bias was exposed against hearing this type of case.
Well, but then if you're going to go down the bias road, so then you're saying that whenever the judge asks, or let's say Denver voir dire is a standard question, it's like, okay, but can you be unbiased, can you put aside whatever bias or whatever and judge this case fairly in a balanced way, whatever. That would obviate any subsequent juror challenge if they answer, yes, I can be unbiased. Otherwise, how do you calculate that or process that or analyze it? If bias is the question, they've already, so you have a juror that's potentially not been truthful in a questionnaire after they've been put under oath, but then they answer under oath that they can be unbiased, and then later you find out, well, they answered a question incorrectly or untruthfully on the questionnaire, but is it material to whether they're whether they would be biased on the jury?
Going to the particular facts of the case, it wasn't shown in this case that this is her ex-husband's and deceased ex-husband's DUIs. It didn't reveal she didn't show any animosity to.
Well, no one could ask that because they didn't know that was actually a fact.
Well, they had that opportunity. Mr. Efferman had that opportunity to show the material, that it was material. He had the opportunity at the evidentiary hearing, and at voir dire, the trial attorney did ask widely about alcohol, but didn't follow up on questions with. When the entire jury panel answered yes to knowing some people that drink to excess, she didn't seem concerned with. She didn't follow up with other questions or individual jurors.
So this would be a different case if at voir dire or if Mr. Efferman would have asked, followed up with, okay, you've had this experience with alcohol. Does that bias you one way or the other? I mean, do we have that in the record? Like, which way would that cut? I mean, we now have learned that she has experience with alcohol in her family, but we don't know which way that cuts. It could cut either way, and that would show bias to the extent that it cuts one of those ways.
Correct, Your Honor.
Do we have that in the record that there's a bias associated with?
We don't have that it wasn't shown in this record to show that it was material it needed to be to expose that was not established in the evidentiary hearing.
Could I ask you about the concealed prong? My understanding of the cases is consistent with what Mr. Efferman said, that you can inadvertently conceal something, which seems weird to me. Is that, what's your response to that?
Not every concealment has to be intentional, but this isn't, but it does have to go to the jury service, and it doesn't, and you can't be, it has to be a direct response to the question that was asked here. It was a vague question, because what is a family? What is, anybody in a jury pool could answer that question differently, could misunderstand that you're talking about ex-husbands or second cousins. And there is an element of having to know that it's responsive to the question.
If you remember with the line of cases, I think there's Busby and Matanzas and a bunch of it talking about peremptory challenges, and if there's a trial judge fails to properly strike a juror for good cause, and the whole song and dance you have to go through to preserve it and then raise it on appeal. I'm assuming you're familiar with that whole line. Now, what do you think why why does the Supreme Court put so much emphasis on the importance of peremptory? So the harm there is that they've been deprived of peremptory that they could have had to exercise somewhere else. Why do you think that the Supreme Court has said that that's harmful to the defendant?
Because they have a right to, they can help choose their jury and make an informed decision on who they want in this jury,
Right.
but
Because that's going to contribute to a fair trial. That's been established for a very long time, that integrated with the right to have a jury is the right to, participate in the selection of your jury so that it's perceived to be fair and that the defendant has participated in that and perceives that trial to be fair, right?
yes, but there was one of the cases cited in my brief where one of the jurors had been out of the room when it was a civil case, but when the parties had agreed to, the juror inadvertently concealed information, remembered it after the fact. It came, unlike in other cases, it came up during trial. The party itself did not want to have that juror on, but in that case, the court found the trial court didn't abuse its discretion by still keeping that juror on. That it's, you can exercise that right, but it also has limits.
Thank you, Ms. Townsend.
May it please the court, there's a couple points I want to make. The first point, Your Honor, regarding the concern about an attorney keeping it in this type of issue in the hip pocket and then bringing it up later. I think actual knowledge matters in that context, and that's this court's Belcher opinion that was cited by the state in its answer brief. In Belcher, the court found that the attorney was aware and then failed to timely file, and in that situation, you're out of luck. So clearly, if defense counsel knew or should have known about juror misconduct during the trial and then failed to bring it up, I think that's always considered a waiver. In this case, there's no indication that Ms. Gooden had any idea that Juror Kuhn had engaged in juror misconduct. It wasn't until the family, as was mentioned in the 3.575 motion, retained Ms. Peterson that this became an issue. Second, after Juror Kuhn acknowledged that everything that was contained in Ms. Peterson's report during the juror interview was true, and that she did in fact have all of these family members who's had issues with alcohol, there was nothing further to follow up on. Whether or not she believed that she was biased as a result of that, that's not the standard for determining whether or not a defendant should be given relief in one of these situations. That's the standard that applies in post-conviction. If you bring up one of these challenges after direct appeal is over and in post-conviction, the Florida Supreme Court recently clarified that the only way you can win in that type of situation is if you can show that an actually biased juror sat on the case. That is not the standard for a 3.575 motion. You simply have to show
Does
that
it roll under the relevancy or the materiality portion of De La Rosa?
it
I mean,
well, it's material, but it's material. Here's the difference. I think in the post-conviction context, where the Supreme Court recently decided, you'd have to show that the juror would be subject to a cause challenge. But at this stage of the proceedings, you'd only have to show that the defense attorney would have used a peremptory challenge. And obviously, a defense attorney can use a peremptory challenge for any reason other than an unconstitutional reason. So in a case like this, that's, as I've argued, and it's already been established that that's what Ms. Gooden believed as well, if you'd have known that this juror had not just an uncle from 30 years ago, but extensive involvement with men in her life that had alcohol-related issues, no reasonable attorney, in light of the facts of this case, 9 to 14 beers, would want to keep that juror on this case. Number three, and I've already addressed this, number four, I do want to point out that, and this is page 442 of the record, when we had this hearing, the second hearing in the case, I was at that hearing prepared to make arguments about why the good cause standard was met and to show that we made a prima facie showing under the three prongs under De La Rosa. I said, and this quote, Ms. Gooden is here, and I would proffer that she would say that had she known the truth about this juror's background, she certainly would have used a peremptory challenge on this juror. And then the judge interjects and says, any objection to talking to the juror? And he's asking that question to the state. And the state responds, ultimately, no, Your Honor, I agree. We should have the juror interview. Any questions or concerns that the state had about the good cause standard, any questions that they had about due diligence, all of those would have needed to be raised by the state right then. The state would have needed to say, yes, Your Honor, I do object. I think Mr. Ufferman hasn't met his burden. I think the due diligence is an issue here. But no, when directly asked by the judge, I think any objection to talking to the juror, the prosecutor agrees that yes, and that's why the juror interview was scheduled.
Well, but I mean, the due diligence to conduct the interview differs from the due diligence that counsel should have done to discover the issue in the first place, right? I mean, those are two different things. And there's no dispute, the trial counsel was out of the country for a wedding.
Correct.
So that, I don't have any problem with that not being a lack of due diligence. But that's a different question than the due diligence as far as whether this should or shouldn't have been discovered before the trial commenced.
And I think we've had this discussion. I'll rely upon the answers I've given. I think this would be a healthy discussion for the Criminal Procedure Rules Committee as to should the rule be changed to require this type of investigation to be conducted in the middle of the trial, but there's no case that says that right now. So for all the reasons I've argued.
Can I just,
of course,
before you sit down, just one quick, going from big to small. So on the cost issue 4, if the trial judge pronounces whatever, fines and costs, whatever, and asks counsel any problem or any objection, and trial counsel says no, is that a forfeiture of the issue for later? I say forfeiture, some would call it waiver, but such that you can't raise it in a subsequent.
I think it's a couple answers, and I apologize if you allow me to answer and give these two answers. I think there's clearly a waiver if, and I was just in a sentencing hearing yesterday and I observed this, if the judge says, defense counsel, do you agree, do you waive me individually reading the cost and fines? And if defense counsel says yes, that's the end of the issue. It cannot be raised thereafter because defense counsel agreed for the trial court to engage in that procedure. Otherwise, though, this court and every court in the state and the Florida Supreme Court has said that this is a notice issue. And if the trial court's going to impose these discretionary fines, the judge has the obligation to do it. So defense counsel there may not realize, and therefore simply saying, I don't object without understanding that that's the law, that's not a waiver of the issue. That's not the same as the trial judge specifically saying, do you agree to me not individualizing the fines and cost? So therefore, I don't think simply saying I don't object waives the issue. And again, the court has put the burden on trial attorneys, trial courts to provide this notice. And I ask this court to continue to stick with its precedent in that regard. To sum up, I don't think these were little indiscrepancies. I think this affected my client's ability to be able to pick a fair jury, and therefore I'd ask this court to reverse. Thank you.
Thank you, Mr. Ufferman. Thanks, both of you. That concludes our oral argument session this morning. We are adjourned.